Legal realism says law isn't just theory, it's what courts actually do. Holmes' bad man theory? It's all about predicting court actions. Legal realists focus on judges, not just laws.
Question 1. Discuss law as the practice of court in the light of legal realism. In this answer, we will be covering introduction, then 10 points. Number 1, meaning of legal realism. Number 2, law is what courts do. Number 3, Oliver Wendell Holmes' Batman theory. Number 4, emphasis on judicial behaviour. Number 5, distinction from other schools. Number 6, role of precedent and statutes. Number 7, contribution of American realist. Number 8, Scandinavian legal realism. Number 9, practical application in modern courts. Number 10, criticism of legal realism, and then the conclusion. Introduction. Legal realism is a school of jurisprudence that emphasizes the practical working of law as opposed to its theoretical or formal definitions. It challenges the conventional notion of law being a set of codified rules and instead views laws as what courts actually do in practice. Hence, the phrase law as the practice of court captures the realist belief that judicial decisions, not statutes or formal principles, constitute the true nature of law. Number 1, meaning of legal realism. Legal realism is a branch of sociological jurisprudence that seeks to study the functioning of law in real-life situations. It asserts that legal rules alone do not determine judicial outcomes. Rather, the personal, social, and psychological background of judges play a vital role. Legal realists believe that legal certainty is a myth and that the law must be studied from the perspective of how it is applied in practice. Number 2, law is what courts do. Realists famously argue that law is what the judge had for breakfast, underscoring the human factor in legal decision making. Unlike other schools that rely on statutes or sovereign command, legal realism focuses on how judges apply law in individual cases. Law is not just in books, it is the outcome of court decisions. Number 3, Oliver Wendell Holmes' Batman theory. Justice Holmes, a pioneer of American legal realism, introduced the Batman theory. According to him, a bad man is only concerned with the practical consequences of his actions, particularly the penalties courts may impose. Therefore, law is a prediction of what courts will do in fact and not abstract moral or ethical standards. Number 4, emphasis on judicial behavior. Legal realists study how factors like judges' personal experiences, societal pressures, and emotional inclinations influence judgments. Jerome Frank emphasized that judicial decisions often depend more on hunches and personal intuition than logical application of statutes. This reinforces the view that law is a human activity and its practice is inseparable from those who administer it. Number 5, distinction from other schools. In contrast to the analytical school, which defines law as a command of the sovereign or a system of norms, legal realism rejects the rigid definitions. It criticizes natural law for being too abstract or historical school for being too retrospective. Legal realism is practical, contemporary, and empirical in its approach. Number 6, role of precedent and statutes. Legal realists argue that precedent and codified law offer only a framework within which judges operate. The final decision depends on how the judge interprets and applies the law, often using discretion. Jerome Frank criticized the belief that legal rules lead to uniform results, calling it a myth of legal certainty. Number 7, contribution of American realists. Oliver Wendell Holmes introduced the idea that law is a prediction of court decisions. Jerome Frank distinguished between rule skeptics and fact skeptics. Karl Llewellyn developed the idea of law jobs and described law as an institution shaped by court practices. These thinkers shifted the focus of jurisprudence from abstract theorizing to real-world judicial conduct. Number 8, Scandinavian legal realism. While American realism is empirical, Scandinavian realism is psychological and philosophical. Thinkers like Alfros, Lundstedt, and Oliver Crona emphasize that law is a belief system with no metaphysical or moral basis. They also dismissed the concept of binding force in law as a social illusion, again highlighting that law exists only so long as it is practiced and enforced. Number 9, practical application in modern courts. Legal realism has influenced the evolution of judicial behavior, especially in common law systems. Judges now consider broader societal factors, including justice, equity, and policy, while deciding cases. For example, courts often adapt precedent to meet contemporary social needs, reinforcing that law evolves through judicial discretion. Number 10. Criticism of legal realism. Legal realism is often criticized for undermining the predictability and objectivity of law. By emphasizing the subjective element in judicial decisions, it is said to weaken the rule of law. Critics argue that realism overstates the personal biases of judges and ignores the role of legal training, precedent, and institutional checks. Conclusion. Legal realism redefines law not as a set of abstract rules but as the lived experience of judicial decision making. Law as the practice of court reflects this core belief that the essence of law lies in how judges interpret and apply it. Despite criticism, legal realism has played a vital role in aligning jurisprudence with practical realities and human behavior with the legal system.